We'll now hear from counsel for the appellant in environmental turf versus University of Florida.
May it please the Court. My name is Ed Scales. I'm here on behalf of the appellant environmental turf. I'm with the Key West office of Gray Robinson. I am the Key West office of Gray Robinson.
You're the whole office, huh?
Yes, Your
Well,
Honor.
Congratulations.
I am the administrative shareholder, the associate, and everything in between.
That's terrific.
At the council table with me is also Hank Campbell from the firm of Valenti Campbell Trone in Lakeland, Florida. May I reserve 5 minutes, please, for rebuttal?
Yes, sir.
My client has appealed the dismissal in this case with prejudice of an amended complaint that is brought under Chapter 119 of the Florida statutes, which is the public records law. And my client's lawsuit below sought relief from both the University of Florida and a direct support organization, or a DSO, of the University of Florida, Florida Foundation Seed Producers.
So the amended complaint, the complaint hasn't been dismissed. It's your client that was dismissed out of the case.
No, Your Honor. Florida,
is there a case still pending against the University of Florida?
Yes, Your Honor.
On the same issue?
Yes, Your Honor.
Is the bid protest still pending?
No, the bid protest was rejected, Your Honor, by the University of Florida, so there is no bid protest currently pending.
Rejected? On what basis?
The University of Florida took the position that it was not the University of Florida's bid. Therefore, Chapter 120 was inapplicable. And that's what this case...
So there is no bid protest?
There is no pending bid protest, no, Your Honor. The University of Florida, there was an attempt to file a Chapter 120 bid protest. The university rejected that Chapter 120 bid protest, alleging that the bid was not issued by the University of Florida.
Okay, this has been several years ago.
Well, all this happened at about the same time, Your Honor, yes.
Right. And so you're trying to discover documents for a bid protest that doesn't exist.
We're not trying to get documents for a bid protest, Your Honor. We're trying to get documents related to a bid submission and a bid solicitation by Florida Foundation Seed Producers. If, depending on the results of those documents, which we have not been able to obtain, we may well be filing a declaratory judgment action or some other action.
Well, are you a little late? I mean, if in fact the argument is true that they didn't have the authority to issue this bid because it was only the University of Florida that had the authority to issue the bid, then why didn't you bring a 12057 original proceeding challenging their authority to issue the bid in the first place?
We did. We filed a Chapter 120 protest.
But you filed a protest on what, not on the basis that they didn't have the authority to even issue the bid in the first place, right? You filed a protest of the whole bidding process to have the bids thrown out on on what basis?
Well, that they had not chosen the correct bidder.
Exactly.
There were several bases.
But not on the basis that they weren't the authorized entity to issue the bid.
We did not know until the University of Florida rejected the bid protest that the University of Florida was taking the position that it was not their bid.
Well, immediately upon finding that out, in light of the fact that the statute has such fine-line time periods, why didn't you file a protest against the...
Well,
because it's too late to file against the bidding authority?
We could still file a declaratory judgment action, or within the time period for filing a declaratory judgment action, if, in fact, the records demonstrate that we need to file a declaratory judgment action.
And is it your contention that even if these documents don't give you any cause of action at all under Chapter 119, you still have the right to inspect them?
That's correct. That's correct. We have a constitutional right to inspect the documents regardless of whether there is a bid protest pending.
Well, I understand that. It's a rather convoluted argument, I guess, because what you're saying is this is the entity, okay, accepted. This is the entity that issued the bid, the one that's not authorized to issue it. Because it's not authorized, the records essentially belong to the University of Florida because they're acting as the agent for the University of Florida.
Well,
Apparently, that's what the trial court's coming up with, though.
that's correct. The trial court,
And I know these proceedings are still ongoing. Did the trial court issue an order ever insofar as following up on its ruling relating to the University of Florida?
no, Your Honor, that is still pending. We have been appealing this portion of the case, and that's the dismissal with prejudice of Florida Foundation seed producers, because the University of Florida has taken the position it's not our bid.
And it was awarded.
It's
In
their
other words, it went forward, the bid was awarded, and that's all over with.
We think the bid was awarded, but we don't. There is conflicting testimony in the case below as to whether the bid was awarded. Attached to the plaintiff's complaint is an email to our client from Mark McClellan from the University of Florida that says the bid was awarded. However, we have not been able to obtain the documents for the bid that was awarded.
But wouldn't it, I don't know. I know what you're saying with regard to challenging, but it just seems to me as soon as you found out who actually issued the bid, because you said you didn't know, you thought it was the University of Florida, and you're taking the position that they're not authorized to do it under the statute, that you would have then immediately proceeded under 12057 to challenge it on the basis that an unauthorized organization has issued a bid that's illegal, because under the statute they can't do it.
That is precisely the catch-22. Who do you file the 120 protest with? Florida Foundation seed producers? They have taken the position that Florida Foundation seed producers is not a state agency subject to Chapter 120. That's the position that Florida Foundation seed producers has taken. The University of Florida, which is a state agency, which we did file the Chapter 120 protest with, rejected the 120 protest and said we did not issue the bid. So leaving ETI in a terrible conundrum, which is the basis of this case. Of course, we've been blocked in our efforts to obtain records which would allow us to answer some of these questions. Hence the chapter 119 request.
No, yes, and I understand all this. I mean, that's what I'm saying. It's very circular. But I'm left with the impression from reading the order of the trial court that's on review here that he's sympathetic to your side, at least that's the feeling I'm getting from the language, that he feels that, okay, so under the statute, I'm bound by the statute. The statute says no public disclosure of these records. But if it's true that this entity does not have authorization and the bids were issued, that in fact they were the University of Florida's bids, that this entity was acting under the auspices of the University of Florida, and therefore the records become records essentially of the University of Florida, which are available.
But the University of Florida has taken the position that they're not their records. They're records of Florida Foundation seed producers, hence the conundrum. Additionally, if in the case below, University of Florida is successful in persuading the trial court in a motion for summary judgment that it wasn't our bid, they're not our records, environmental turf, my client is left without a Chapter 119 remedy.
Is the University of Florida taking the position that, we have the records that you're requesting from the Florida Foundation seed producers? We have a copy of those, but we can't give them to you because they're records. Or are they saying, we're going to give you a copy of the stuff we have, but we don't have the stuff that you're asking for because it's their records, they have them, we don't have them?
It is the latter.
Okay.
It is the latter, Your Honor, which is one of the main reasons why we're here. Our discovery has determined, our discovery on the ongoing case has established there are records related to this bid that have not been turned over based on the exemption that has been raised by Florida Foundation seed producers, which is the DSO exemption.
All right, if the answer is the latter, then what records relating to the bid have been turned over?
Several pages of documents, several hundred pages of documents have been turned over.
Relating to the bid process?
Relating to the bid process.
So the University of Florida, essentially, if they gave it to you relating to the bid process, then are they giving it to you as relating to the bid process? As their records? Or as the records of who had them originally? The seed authority?
Presumably presumably, Florida Foundation Seed Producers, the direct support organization, had all of the records.
Okay, but they've given you the records that deal with the bid process. So in effect, does that mean that they are agreeing that they in fact were the bidders and the seed was acting as their agent?
Make no mistake, Florida Foundation Seed Producers and the University of Florida have taken the position in this case consistently, and take that today, that it was the bid solicitation of Florida Foundation Seed Producers and not of the University of Florida. We have taken the position that Florida Foundation Seed Producers, if that is correct, then Florida Foundation Seed Producers was acting as the agent of the University of Florida, and therefore the DSO exemption, which is very narrow, does not apply in that particular instance.
And that's an issue still pending in the trial court, because the trial court hasn't ruled on the University of Florida's requirement to disclose the records that deal with the bidding process, all the records, because you've gotten partially, all the records that deal with the bid process.
But that is correct. But if the trial court makes the determination that those records that still have not been produced, and there are records that still have not been produced relating to that bid process, are FFSP's, the DSO's records, then ETI has been thwarted, and we don't get those records.
Well, what can the trial court do? He's following the statute. These records of this agent, if they in fact are the records of the Foundation Seed Producers.
Well,
See, what you're saying, it seems to me a better argument that you'd be arguing that the seed producers don't have the authority, and therefore all the bids had to be thrown out, rather than saying they don't have the authority, and therefore whatever they did, we're entitled to their records.
Judge Davis,
Is that what you're arguing?
We may get there. We're not even there yet, because we don't have copies of all of the records that would establish those things. For example, has the bid actually been awarded to the cooperative? We don't know the answer to that question. We have one document that's attached to the complaint indicating that it has, but we don't have a copy of the actual, that other document.
If all this comes to pass,
Yes.
and did you appeal the dismissal?
Yes, the dismissal with prejudice of Florida Foundation Seed Producers, Inc. That's this appeal.
This is the dismissal from the trial court.
That's correct. There's not been an evidentiary hearing. There's not been an evidentiary.
I'm talking about the agency's dismissal of the bid protest.
That has not been appealed, because there was never a determination. The University of Florida simply said it was not our bid. We are not going to entertain your Chapter 120 request, and Florida Foundation Seed Producers is not a state agency. Therefore, Chapter 120 does not apply to them.
But if you had brought it challenging the seed authority's jurisdiction to enter the bid and challenged it on the basis that for that reason the bidding process should fail and all bids should be thrown out.
We will not disagree with that.
Then you would have had an appeal of that if they had denied it, and your bid process would still be in the up and down. It'd still be right. But now, under the statute 12057, I used to do bid protests all the time, and the time periods are so refined and required. So were you to achieve what you want here, you say we can go back and challenge, but how? Even if the bid hasn't been issued.
We could do a declaratory judgment action under Chapter 86.
Under due process?
There could be several constitutional rules under Chapter 86. But again, we're not here on a 120 proceeding. We're here on a Chapter 119 case.
I know what you're
We're entitled to the records irrespective, Your Honor, of what the reason is that we want the records.
But wait, whose records are you entitled to?
Florida Foundation Seed Producers, if in fact Florida Foundation Seed Producers was acting as the agent of the University of Florida in conducting this bid solicitation.
But if they were acting, once again, we're sort of going in a circle here. Once again, if these are the records of the Foundation Seed Producers, then they're exempt under the law. Your argument is they're acting as the agent. So they're really not the records of the foundation seed producers. They're the records of the University of Florida, and therefore they need to be disclosed. That seems to be where the trial court was going.
The problem with that is that the exemption is not as broad as the trial court characterized it. I note that I'm out of time. I assume that is...
Well, let me tell you, one of the advantages of being last is there's room for flexibility. So what we can do is extend the time, and we'll extend it to the other side too. What we'll do is we'll have you respond to the questions, and then we'll give you about 3 or 4 minutes for rebuttal that we'll add on to it.
Thank you, Your Honor. And I believe, go ahead and do that now.
Sure, go ahead.
Thank you, Your Honor. I believe the question was, depending on whose records they are we suing the right party for the records?
Well,
and the exemption.
And essentially, you're suing both.
That's correct. And the key question in this case, and the question up on appeal, is whether the exemption being relied upon by the direct support organization is applicable under the alleged circumstances in this complaint. Because remember, on a motion to dismiss, all of the well-pled facts are alleged as true. In this case, the allegation is that Florida Foundation Seed Producers was not authorized. It's not an authorized function for a direct support organization to conduct sponsored research on behalf of a university. They did that anyway. Therefore, the exemption, which is to be narrowly construed, is inapplicable. And if you look at direct support organizations, they have a very limited role. Their role is to receive, hold, invest, and administer property for the university, for the benefit of the university. And the statute uses the word exclusively. And the rationale for that limited scope of direct support organizations is so that it's very clear that they can only do certain things because they are authorized under the statute to use the University of Florida's personnel, to use the university's facilities, to use the university's cachet and their name. So they're basically authorized to be adjuncts of the university. And make no mistake, my client has no problem with the application of the exemption from public records, so long as the direct support organization is receiving, holding, investing, and administering property for the university. That's not what happened here. That's not at all what they did. What they did in this case was they undertook a specific university function, which is sponsored research, just like taking over the English department.
So on that basis alone, forget the records. On that basis alone, the argument you're making is a great argument to have made in a 12057 as to why they weren't authorized to issue the bids and why all bids should be thrown out without getting into any discussion of who was the best bidder or most qualified or whatever.
I don't have any argument with that, Your Honor. None at all. But it's also a very strong argument that as a matter of public policy, under Article 1, Section 24, Sub C and Sub A of the Florida Constitution, and Chapter 119, we have an absolute right to those records generated by the direct support organization in what it was doing. And the case law is absolutely clear and absolutely consistent. There's an unbroken line of 12 to 15 cases that say when a private entity is acting on behalf of a public entity, the records of that private entity created in conjunction with doing that public entity's work are public.
They become the records of the public entity, is what the...
Actually, that's the case law is that the agency becomes the private entity. For example, in the Books and Million, or in the Barnes and Noble case, the Florida FIU down in Miami had contracted with Barnes and Noble to run their bookstore. A competitor, I think it was Booksmart, sued Barnes and Noble, not FIU, Barnes and Noble, saying, we want the records that are generated by you in running the bookstore. And the third DCA, I think it overturned the lower court, but the third DCA said, in fact, the Constitution is clear that you become a public agency, and Chapter 119 defines a public agency as a private entity that is doing the bidding for or acting on behalf of a public agency, which is precisely what happened here.
Okay, so you say that, if I'm an officer of the executive branch and I have public records and I give them to my next door neighbor, to keep in his garage. You can bring a 119 action against me and him.
That's correct.
To have him produce those records.
That is correct. And the question then becomes, and there's actually a Supreme Court articulated test, it's 12 factors determined by the Supreme Court in the Schwab case, as to, it's a factual inquiry as to whether your next door neighbor, in fact, is an agent of you for the purposes of Chapter 119. Because Chapter 119's definition of public agency not only includes public agencies like the University of Florida, but any private agency or entity.
But it's only those particular records he gave you. You can't go further and get all of his other records that...
That's correct. And we're not asking for those in this case. We're not asking, for example, for records from Florida Foundation seed producer that has anything whatsoever to do with their investing property or administering property of the university.
Contributors.
Or contributors or donors. In fact, the specific Chapter 119 request to Florida Foundation seed producers in bold letters says we are not asking for the identity of donors. And the rationale behind the DSO exemption is to protect their mailing lists, the names of their donors. That'd be very valuable information in the private sector to go to the University of Florida Foundation and figure out who's giving them what and how much they're giving them. Similarly, investment strategies of these direct support organizations, these foundations, are protected. We're not asking for any of that information. In fact, we're only asking for the information and the records that were generated by this direct support organization when they were performing a University of Florida function that the university would ordinarily conduct itself, which in this case is sponsored research.
Okay, I think we have it. Now what we'll do is we'll give you 3 minutes for rebuttal, and we'll put 24 minutes on the other side.
Thank you, Your Honors.
All right, thank you.
Mr. Wheeler told me not to do that.
I don't know why they don't put something on that. Maybe they tried and nothing works.
May it please the court, John Duvall, my law partner Courtney Grimm, for Florida Foundation seed producers, the appellee in this court. And I appreciate the additional time, Your Honor, but I don't think I've ever spoken for 24 minutes on any subject. I don't purport to know that much. The sole issue before this court, Your Honor, is whether the documents created in connection with Florida Foundation seed producers' activities to administer property for the benefit of the University of Florida are exempt from the Public Records Act pursuant to 1004.28. This is not a private entity. It's not a next-door neighbor. It is a not-for-profit corporation created specifically to assist and administer property for the benefit of state universities pursuant to a special statutory designation. A DSO is permitted to use university property. University employees administer their business.
In this case, what is the property that...
The property is the intellectual property created by the IFAS,
okay.
University of Florida Agricultural Extension Service. It is to be a cultivar, which would be a St. Augustine grass resistant to chinch bugs. Now, up here in North Florida, that's not a big thing. But in South Florida, to have a St. Augustine grass that is resistant to chinch bugs could become a very profitable activity. The documents attached to the amended complaint show that the IFAS, through one of the professors working with the IFAS, came up with this cultivar. What the University of Florida sought to do was to assign this property, this prospective valuable property, to the DSO so that the DSO could negotiate with an entity that could develop and market this product. If successful, perhaps like Gatorade, it would bring a lot of money to the University of Florida. It would bring also money to...
Why wouldn't the IFAS do that itself rather than assign it to the DSO?
Well, because the IFAS, for whatever reason, prefers, once it gets to a certain stage, to take advantage of the creation of DSOs to administer their property. The IFAS has the statutory exemptions for the public records, so it has nothing to do with the Public Records Act. but the DSOs are created for the purpose of benefiting the University of Florida and administering property. Then there are numerous DSOs created by this university and others for various functions, research functions to take care of the production of citrus trees for the 4-H clubs, in addition to the University of Florida Foundation, which collects money for the university. So the IFAS, in this instance, as shown by the documents attached to the amended complaint, decided when it got to this particular level that they wanted to let the DSO send out this proposal. And although it's called a bid, it really isn't a bid. It's a request to negotiate with the applicants to see who would be best served in order to benefit the university. And the applications came in. Yes, sir.
One of the problems that universities have that you read about in the paper is, when they're hiring a president or a dean, an issue comes up that people from out of state or that work at a good university don't want to apply because the fact that they applied would be in a public record. Why couldn't the University of Florida, if they were searching for a new president sometime in the future, allow one of their DSOs to do the president search for them?
Well, they'd probably like to, Your Honor, but they couldn't. And the reason they couldn't is because 1004.28 subsection 1A2 defines the specific things that a DSO can do, which is to receive, hold, invest, and administer property, and to make expenditures to and for the benefit of the state university. So the search for the president, or putting together a book list for Barnes & Nobles, some of these other activities that have been suggested simply wouldn't come within that definition. They would be ultra vires, and therefore a DSO could not accomplish those things. It can only do what is permitted to do under the statutory definition and under its not-for-profit charter.
Help me understand, Mr. Duvall, what the public policy rationale is for exempting from Chapter 119 an activity like this. Now, I'm not talking about the DSO generally. I'm talking about specifically this request for proposal or bid or whatever it is you call it. I mean, we're talking about a lot of money here.
Absolutely. And I think the public policy is clear on its face, Your Honor. These are proprietary information. The creation of this cultivar or the creation of Gatorade is a formulation that is valuable only if it is restricted and can be licensed to a particular party to market. So the property that is the subject of this application perhaps could become a very valuable property, but only valuable if it's restricted in terms of the DSO being able to direct it to a particular company and have exclusive rights. The same reason we have patents and license agreements.
Well, I understand that, but what value is there in keeping the public out of knowledge of what's going on?
Well, if a competitor of the company that received the successful bid could come in under 119 and say, we want to see, as they've done, all of the documents relating to this cultivar, then that competitor could take that information and develop their own competing brand, and therefore the University of Florida, the license that they issue, would have little or no value because every other company that wanted the information could get it. So,
well, you mean there was some information that was given to some companies that wasn't given? Because my understanding was that the necessary information was given to these folks who are the appellants here. That's not right.
No.
I'm not talking about the paperwork. I'm talking about the information so that they could make a proposal.
All what they were told in the application or solicitation for bid request is that Dr. Delgado has developed this cultivar of chinchbug-resistant St. Augustine grass. They didn't describe in that, nor would they, what he had developed or the information that would be beneficial to a competitor for use. What they said is, you want to come in and tell us how you would market such a product, how much money would you advance to us for that benefit? So no, they do not have that.
Well, was additional information given to other potential folks who might perform this service?
It would be given as part of the process of the negotiation to bid.
You mean after some decision had been made about which firm would be involved?
Absolutely.
So they're not just asking for information leading up to a determination as to which firm would be involved.
No.
They're asking for confidential information that was revealed thereafter. And is that the only thing that's in dispute here? I mean, is documentation prior to that determination also being withheld?
Well, the bid, what they want is all of the information that the DSO has with respect to this cultivar.
Right.
And it would include the information from the company that was the successful bidder and what they would do, their marketing plans, which certainly would be proprietary information, the information the university sent back to them with respect to the nature of the cultivar. So all manner of information passing between the DSO and the successful bidder to make this product a success for the benefit of the university.
So that's the reason that IFAS sends this over here, so it can't be revealed.
Not completely, Your Honor. IFAS
That's a benefit, though.
It is a benefit, but IFAS itself has a research exemption under 1004.22 protecting its patents while it's working on something. So it has a comparable exemption. So I don't want to suggest that it's only because of that. IFAS has its own research exemption. I think it's more the fact that the DSOs are better equipped and more used to doing these marketing tools. They do it with blueberries, they do it with plums, they do it with all manner of fruits and vegetables produced for the state of Florida, for agriculture within the Florida, for ultimately the benefit of the universities that do it.
I'm trying to understand the nature of the trial court dismissed the complaint, but I'm trying to understand the nature of that dismissal. The trial court ruled that 104.28 sub 5 applies for all purposes for any information that the DSO has, or did it rule on the issue that Mr. Scales raised that the activity of the DSO was not ultra vires, so the issue of acting on behalf of doesn't apply?
Well, he did not make an express ruling on the latter point, Your Honor. The plaintiff certainly raised that argument that it was ultra vires, an ultra vires activity. The judge's response was, well, if it's ultra vires, I'm leaving the University of Florida in. The DSO is an agent of the University of Florida. If it was ultra vires, you get the documents from the university. You haven't lost anything. What I'm saying, and what his order said was, the documents of the DSO.
Well, does the university have all the documents? I think I asked a question about this. Or are there some
No.
documents that belong to the DSO? If the judge rules university, you turn over all the documents. And the university says, well, you have everything we have.
The university has turned over 850-some pages dealing with this, which were in their possession, and pursuant to the judge's order, prepared a privilege log with respect to the documents they've withheld on the basis of the research privilege and attorney-client privilege. So,
But if the judge finds later that the DSO was acting ultra vires and decides that the documents are in fact the University of Florida's documents, he no longer has the DSO before him to issue them an order.
No,
Right?
I would disagree, Your Honor. Okay. I think if he holds that it's ultra vires and they are acting as an agent of the University of Florida, which we acknowledge, then the University of Florida produces those records, just as in the case you example where you have the records and you give them to your neighbor. You don't need to bring the neighbor in. If he's your agent, you can get them from you. So. Well,
if the neighbor doesn't say no at that time.
Well, if the judge were to hold that it was an ultra vires activity, then the documents, as he said in his order, could be obtained from the university. But one other point, Your Honor, I think that's important here. Here we have not just the allegations of on the face of the complaint, but we have the documents that are attached to the complaint which shows what the activity was. the activity that I previously described. That is, a cultivar developed by IFAS that a DSO was promulgating for marketing purposes. The judge found implicitly that that was an activity appropriately for the DSO under 1004.28, so that when you have the documents attached to the complaint which negate the allegations of the complaint, the judge can make that finding. Analogous is a case which I think Your Honor is familiar with, the Findle case versus the Palm Beach County Canvassing Board. And in that case, Your Honor will recall, plaintiffs said these ballots in their allegations were materially defective on the face of the complaint, but the ballot itself was attached. The Supreme Court said, well, no matter what they alleged in the complaint, you look at the ballot and you see it's not substantially defective. The trial judge was right in dismissing the complaint. So here, they've alleged in their complaint, well, these activities are outside the scope of what a DSO can do. The judge looked at the documents that were attached to the complaint, which showed what was happening and what was being done. That is, the DSO using property for the benefit of the University of Florida, and said, hey, I can look at that and see that these are appropriate activities. The statute protects the documents of the DSO for production, so I'm going to dismiss the DSO but let you continue your action against
That's implicit, though, right?
Absolutely.
Okay. You know, you see where my concern is. I'm concerned with this court issuing an opinion that says 1004.285 exempts the public records of a DSO from disclosure, no matter what the DSO is doing. I'm concerned about that.
And I think that is a legitimate concern, Your Honor. And if the facts were otherwise, that certainly would not be appropriate. If it were running an English department or a search, then they're clearly outside, and it would not be protected. But here, implicit in the court's finding, and this court, because it has de novo review, can see the documents attached to the complaint that what was being done was pursuant to the activities of an appropriate DSO. And once that's determined, then the remedy, plaintiffs, for whatever reason, having not chosen to challenge under 120, as Judge Davis suggests they could have done, they can go against the University of Florida. They've taken, I think, 8 depositions thus far. They've got a half a dozen more set in the next 2 weeks. And they'll continue on their action against the University of Florida. And if they were to prove that there was some ultra-virus activity, they would still have a remedy with respect to these documents. But the judge made the correct decision we submit with respect to the DSO. Unless the court has further questions, I'll yield the rest of my time.
All right. Thank you, sir.
Thank you, Your Honor.
May it please the Court. To clarify a couple of things that I think are critically important. There has been no property developed. In response to your question, Judge Roberts, I believe counsel for the University of Florida and FFSP indicated that property had been developed that was going to be administered as contemplated by the DSO. I'll make this absolutely clear, and at page 216 of the record is the actual bid request. It is for development of the property. So, and this is very important because counsel just suggested to you that the rationale for the DSO exemption was to protect research that had already been created. This is not that situation. This is a bid requesting funds to pay for research to develop property. Here's the distinction, and we've talked about this in lemonade stand terms. Somebody dies and gives a lemonade stand to the University of Florida. The University of Florida Foundation can operate that lemonade stand. That is property to be administered by the direct support organization. The Department of Business Administration, though, at the University of Florida, wants to develop a better way of selling lemonade. They issue a company-sponsored bid solicitation to develop that program of making lemonade. The former is what a DSO does, administer property given to or already created by the university. The latter is what a division of sponsored research does, which is an arm of the university. In this case, it is very clear the grass cultivar had not been developed.
What if it had been?
I'm sorry?
If it had been, would you be in agreement with their argument?
It would depend, but we don't know. For example,
But I mean, if you'd known and it had been evident in the proposal to negotiate that it had been developed and all they wanted was somebody to market it.
I think that would probably be a different set of facts. But, Your Honor, it would depend on several things. And in
Because
fact,
that in fact would be an administering of property.
well, if in fact the university had already licensed that intellectual property to the direct support organization,
Exactly.
and via contract or otherwise said, here, direct support organization, we want you to administer this property that we have already created.
We want you to market it.
Market it or administer it.
That would be different.
I think it would be a different situation entirely. But again, we are left with the facts that are alleged in this complaint. And those are facts that are not alleged in this complaint. And in response to Judge Allen's question regarding what is the purpose of the DSO exemption, I think the answer was, to protect research. Let me be very clear. There is a separate statutory provision that exempts research, trade secrets, those types of things that had not even been developed in this case from disclosure under Chapter 119. That is an entirely different situation. And the judge did not rule on that, nor to take that into consideration. That issue has not been developed. There are factual issues and the court has brought them up adequately, that need to be addressed. To dispose of this case at the dismissal stage without a single bit of testimony, without any evidence whatsoever, without an analysis of what the relationship is between the direct support organization and the Division of Sponsored Research, what other universities do, what the rules are in relation to the Board of Governors, which used to be the Board of Regents. All of those are very important for the trial court to make a determination on whether or not this, in fact, was a authorized delegation by IFAS to the direct support organization.
And is it, even with this entity out of the case, to make the final determination, is it not going to still have to address those issues?
I think we are, but absent, I think we definitely are, but absent Florida Foundation seed producers in the case, the court lacks jurisdiction to force them to produce the records.
Not if they're not their records.
Well, I'm sorry?
Not if they're not their
Well,
records.
as Mr. DeVault just said here, there are records that FFSP, the direct support organization, has that they have not shared with the university. So,
But if they're the agent for the university and they do deal with the bid process, then the trial court can say that they are the records.
the trial court could say that. But let me be very clear about Chapter 119 in defining what an agency is for the purposes of turning over records. An agency, and the Constitution, by the way, specifically includes in the definition of agency entities working on behalf of public agencies. And the concern that Judge Roberts has, I think, is a very real one. In this particular case, you have an allegation that is actually supported by attachments to the complaint that the direct support organization is conducting unauthorized activity. For this court to affirm on that record would clearly send the message, and I think we're all University of Florida law graduates, everybody sitting here, we could creatively think of ways that DSOs could start to operate functions of the university and avoid the transparency requirements of Chapter 119.
But as you said and opposing counsel said, the trial court didn't rule on the issue.
I think impliedly he ruled on the issue. Or if he didn't rule on the issue, it's very clear because the allegation is in the complaint.
I understand, but I mean, I can't tell from the record, from his order, that he addressed that issue, that he addressed anything more than the statute says, and this is, and so therefore.
I would agree. However, the trial court is also bound to construe exemptions to the public records law very narrowly. And in this particular case,
thought he did here.
Again, I think it's a pretty broad. I think in light of the allegations of the complaint, it's about as broad of a construction as you can get for an exemption to say, even though they've alleged that what the DSO was doing was outside of their statutory authority, we're going to protect those records. That's a very, very broad construction, in my opinion.
Well, it's a problem for us to reverse a ruling that doesn't exist if, in fact, what you want us to do is review the issue that you wish
Well,
you'd addressed.
and again, I'm not asking the court to do that, but I do think it's implicit, given the fact that in the allegation of the complaint is that the DSO was acting unauthorizedly. The court had to accept that allegation as true in making his order. So therefore, if you affirm the dismissal of FFSP, implicit in that is that even if there is an allegation that the direct support organization is operating unauthorizedly, the exemption nevertheless controls. And that would be the direct implication.
Thank you, Mr. Scales.
Thank you.
Mr. Duvall, thank you all. Okay, you may. We made note of that. All right, thank you.